wishes to put in information about the December 3rd interview, only as far as Dr. Dudley's observations of improvements in Philip Chism's condition from the other times that he had seen him. And due to the risperidol, the antipsychotic medication. The Commonwealth opened the door to this when the Commonwealth inquired whether Philip Chism had refused the medication the last day at the hospital.
Last day at the hospital, on what day?
It would have been November 4th, I believe, was the day of discharge from the recent admission to Worcester Recovery Center. It also came up in the jury has already heard about the December 3rd interview because the Commonwealth asked broad questions concerning whether Mr. Chism had expressed remorse. And though this information is certainly relevant, it's certainly is supportive of Dr. Dudley's opinion, but also it answers in relevance issues that have been raised by the Commonwealth in its cross of Dr. Jackson and Dr. Dudley. And I did not give notice to the Commonwealth on Friday before Dr. Dudley got on the stand. I did have Dr. Dudley write a report on Saturday, and I provided that late Saturday to the Commonwealth.
Okay. Well, but specifically, the first issue, the cross-examination, Commonwealth inquiring refused risperidol on the last day at the hospital, November 4th, 2015. Keep in mind, we're in a state of mind more than 2 years after the incident that came into play because of Dr. Jackson's testimony about a state of mind at the same time as competency evaluations. And the argument from the defendant was, concerning the low bar to probative value, that would say something about a state of mind 2 years later. That's not a clear call to admit that evidence that the defendant requested, but considering the standard of relevance, I decided to allow it. So that's how we're in this position. Just keep that in mind. That's how we're in this position, because the state of mind that's pertinent in this case is not December 3rd, 2015, but October 22nd, 2013. So the Commonwealth inquired about the risperidol at the last day of the hospital. As I understood the Commonwealth's purpose in that question, it was as it relates to malingering or not malingering issue, which was a pretty narrow issue. Am I correct in the reason for the cross-examination in that area?
Yes, sir.
Okay, so the cross-examination had a sliver of relevance as it relates to the malingering. Now, as far as agreeing to take risperidol on December 3rd, 2015, and actually before then, what the defendant is seeking to do is to not rebut that narrow cross-examination, but get a new opinion after the Commonwealth has rested. I mean, it's not difficult to understand what the new opinion is. The new opinion is, see how he acts with risperidol. Let's look back and see how he acted without it. It's not brain surgery to figure out that this is not to rebut malingering one malingering question on cross-examination. So other than that, that's the relevance issue. As far as the December 3rd interview and the Commonwealth's ability to respond, in addition to countlessly citing the SJC's recent comment on expert testimony and disclosure in Case versus Lang, that I think says a lot, despite the issues in Commonwealth versus Handwright, footnote 4 of Commonwealth versus Handwright. Putting all that aside, what we have here is not a rehabilitation issue. It's a new grounds of criminal lack of criminal responsibility. I mean, it's not. What's going on here is not to rehabilitate that one question on cross. What's going on here is we want a new opinion in. This new opinion, based on the testimony after the Commonwealth rested, is this. Look at him on risperidol, comparing to when he wasn't on risperidol. That's the purpose, not to rehabilitate something that happened on cross-examination. With that said,
November 4th, making it more relevant.
I mean, put aside for the moment, just drop for the moment the disclosure issues. Drop for the moment all the disclosure issues.
Who has psychosis to respond is certainly relevant. It's as relevant as what the Commonwealth is going to offer. And the Commonwealth, in asking the question, did he refuse the medication on the last day, did open the door to the inference that he didn't need the medication and he wasn't taking it and he just took it at the hospital to put on a show or something. And Dr. Dudley's observations of the changes in him and the positive effect that the medication has had would be highly relevant to refute the inference the Commonwealth has created with its questions.
I didn't take the cross for that purpose, but let me hear from you, Ms. McDougall.
It wasn't for that purpose, Your Honor. It was simply to show that the day before he was going back to court to be evaluated for competency, he purposefully declined the medication in order to make his symptoms look worse before he came back to court.
Well, that was my understanding of the purpose of the cross.
Your Honor, I don't want to spend very long on the disclosure issue, but I do want to at least touch on it because I think the Commonwealth has been put in a really untenable position on a variety of disclosure issues, as was discussed at sidebar, because absolutely nothing in the discovery gave the Commonwealth notice that Dr. Dudley had ordered the brain scans. I never would have asked those questions but for that. Additionally, the notice I was finally given on Saturday regarding the December 3rd meeting says absolutely nothing about Mr. Chism feeling any appreciation for the difficulties he's put the family through. I wouldn't have asked that question. I didn't follow up and cross-examine because I didn't want to open the door to this interview, which I had only just been given on Saturday in the middle of my cross-examination. So the Commonwealth has already been badly hamstrung by these disclosures. It's not just a matter of me standing up here and complaining because stuff's been filing late. This is a situation where this whole issue of the risperidol from the beginning has been a problem. Had I known that Ms. Regan was going to reference as an opening, we could have litigated that. Instead, she said it in opening and I was stuck with it. And then we have Dr. Jackson on and I had to ask for a voir dire to make sure that that wasn't going to open more doors. And then all of a sudden on direct for the first time on Friday, I learned that on a day when Mr. Chism waived his appearance to be in court when we argued the Dober-Lan again, clearly it was a planned meeting between him and Mr. Dudley and I learned about it during the direct. So the Commonwealth has been incredibly hamstrung. And at this point, it would be incredibly prejudicial to the Commonwealth. Frankly, I've already gone places I wouldn't have gone in reliance on materials that aren't reliable.
All right. Well, first of all, there's a serious probative value issue. There was a case I read just over the weekend where Judge Welch excluded evidence of a defendant saying he heard voices to certain people months, maybe even weeks after the incident that was excluded. And not only is it the hearsay issue looking backwards as to state of mind, but it's a probative value issue. If there is a probative value, to the defendant's medicated state, 2+ years after the incident, and that is a huge if, which I, even with the low standard of probative value, have serious concerns that it has been satisfied. It is substantially outweighed by the unfair prejudice as it relates to all too many issues, and the court is not going to waste time repeating what I already said. So I seriously question any probative value to it. If there is probative value to it, it is extremely minimal and needs an opportunity to be litigated after disclosure as to whether or not the court is going to allow that in as a basis for the opinion. I mean, the language, the vigor, the seriousness, the shout across the bow language of the court in Case versus Lang could not be clearer. The concerns that led to footnote 4 of handwriting, to the whole concept of handwriting, the proposals before the SJC could not have been clearer. The December 3rd interview is not admitted for two reasons. One, it is of extremely limited probative value as it relates to October 22nd, 2013. And two, if there is any probative value to it, substantially outweighed by the danger of undue prejudice for the reasons outlined by the court and referenced in more detail than the court really appreciated in the Commonwealth's argument. All right, let's take the morning recess. Your objection is noted, and we'll reconvene. If everyone's ready, we'll reconvene a little bit before 11.
I ask that Dr. Dudley's addendum 2, December 5th, 2015, be marked for identification as an offer of proof.
Amen. All right, put them in recess.
All right.
Her testimony with respect to schizophrenia, but other than that, I had no objections to her testimony as an educational witness. But I'm now faced with, once again, having my cross-examination badly hamstrung by I can't ask a question that is a completely fair question, because the answer is going to be that she reviewed some records that I learned about literally within the last 10 minutes.
Well, the records that you'd have to inquire of on cross-examination, though, would be radioactive records, wouldn't they?
Yes.
All right. Well, first of all, Ms. Regan, I'll hear from you on the notice issue relative to this witness, Dr. DeVere's, now being more than a teaching expert.
Your Honor, I do not intend to call Dr. DeVere other than as a teaching expert. About 2 years ago, she did review records of Philip Chism from Boston Medical Center and from the Worcester Recovery Center. At this time, she has no present memory of those records.
All right.
But she did look at them, and I don't intend, I mean, her testimony is clearly as an educational expert.
All right, because I think you need to interrupt her if she says something that's going to open up the door to June 14th. It's not your, I know it's not your nature, but you're just going to have to put your hand up and stop her mid-sentence if she does something that's going to open up a cross-examination inadvertently. Paul, they can start to gather. And otherwise, this will just be the analogy I think I made was to, in the child sexual abuse cases, so that there not be any vouching, that there be no connection to the defendant in the case. Was there any issue that you had that'll save the sidebar, Ms. McDougall, because you said that you might have an issue?
Well, Your Honor, I'm very concerned at this point about the notice I've been given about her testimony, because I don't know what's going to come out of her mouth based on, the last thing I want to be doing is standing up here or approaching sidebar on issues of disclosures at this point in a trial. It is not something the Commonwealth takes any pleasure in, but I have a brief paragraph that has changed. I've just learned, yes, it is exactly the same as the child abuse context, which is why I wasn't objecting. I can't fathom that the Commonwealth being entitled to call an expert who had reviewed the victim's records in a child sexual abuse case. So it's not, because she's been allowed to review records in this case that, as the court has pointed out, are dynamite. The Commonwealth has moved heaven and earth not to go anywhere near that, and an abundance of caution.
So here's the problem. The problem is it's on the defendant, not the Commonwealth. That's why I told Ms. Regan to be rude if she has to be rude, to stop, because if they open the door, they open the door.
I don't want them to open the door. So the person who's truly hamstrung is the Commonwealth.
Well, you don't want them to open the door for reasons having...
Because it's a door I would never walk through.
No,
because the SJC would judge me very harshly for walking through
well,
that door.
that's the point I'm making, is that if it opens, it opens. I can't imagine that Ms. Regan is going to ask a question that's going to allow that door to open. Well, the request, I guess, is that because she reviewed the record, she shouldn't testify?
I've had 5 minutes to think about it, and that obviously has implications that are concerning to me.
It's
but
more concerning than the defendant opening the door. Here's my take.
The defendant's error, the defendant's failure, once again, is only going to hamstring the Commonwealth. The fact that she has to be careful about asking about June of 2000.
Hold on, let me ask you this, because, just hold on 1 minute. The problem is this. The problem is that if she testifies differently than the disclosure because of what she reviewed, then the 614 incident is going to be available for cross-examination. So, there's two possibilities here. There's three possibilities. The third one I'm not going to do, which is to spend time augmenting what I already said about handwrite and case versus line. So that's one option I'm not going to do. Another option is that she testify according to the disclosure analogous to a child abuse case, where, as you said, the Commonwealth, according to the doctrine, has to, with kid gloves, make sure that the expert in no way has any contact with the alleged victim, so that there's no vouching. And that's the analogy here as a teaching expert. Now, you've made your point, and putting aside, because it doesn't do any good this moment, but I've already made my comments that I've made concerning disclosures in case and handwrite. The issue now is on the record that this has happened because of the defendant's making. There's two possible rulings here. One ruling is she doesn't testify. The other ruling is if she testifies and opens the door to 614, she opens the door. Let me just tell you, it seems to me that the situation has arisen because of the defendant's choices, and it seems to be that number two is a lot easier to argue. Hold on 1 minute. Hold on just 1 minute. Hold on 1 second. Number two is a lot easier to argue than excluding a teaching expert, should there be conviction.
Except number two is a door I'm never going to walk through.
Well,
So I will not be forgiven by this SJC for introducing evidence that will ultimately lead to a prior identical incident. So there is no number two for the Commonwealth, because I'm not going to do that. And I should never have been put in this position.
well, if it comes out on direct, that's your choice, because I don't think being in the business of predicting what the SJC is going to do is an easy thing to do. But if it opens, it opens. And the defendant has strong reason for it not to open. And this is a box built by the defendant. So if this expert does anything beyond what was noticed as a teaching expert, then the implications are the implications. But I don't see this is what I'm saying. I got two choices here. I think the not allowing the expert to testify is a more precarious choice than the defendant calling the witness, having them review records, tying those records or any testimony to this case, and opening the door to an incident that would otherwise be inadmissible. And so I am forced to make a choice between two untenable positions, and in making a choice between two untenable positions, I'm choosing the one that I think is more likely, should there be a conviction, to be understood than the other.
I would ask that Ms. Regan put on the record exactly what Dr. DeVere has reviewed, so that I am not forced with not knowing. I would additionally also ask to be heard unrelated on the issue of the extent to which she can testify regarding the presentation, diagnosis, and treatment of early onset schizophrenia in children in the absence of any testimony that Mr. Chism has schizophrenia.
All right. No, have them. So you want to be heard right now on the issue of what she's going to, what the offer of proof is as it relates to schizophrenia?
Sure.
Okay. What's the offer of proof? We can hold in there for one more second. Okay. Ms. Regan, what's the offer of proof?
Psychotic, not otherwise specified, also known as unspecified schizophrenia spectrum, and other psychotic disorder. This category applies to presentations in which symptoms characteristic of a schizophrenic spectrum and other psychotic disorders but are present but don't meet the full criteria for any of the disorders in the schizophrenia spectrum. The unspecified schizophrenia spectrum and other psychotic disorder category is used in situations in which the clinician chooses not to specify the reason that the criteria are not met for a specific schizophrenia spectrum or other psychotic order. Psychotic symptoms occur in children, and they often are a prodromal stage of schizophrenia. Psychosis in children and youth occur as part of depression, bipolar, and schizophrenic spectrum disorder. The symptoms of early onset schizophrenia have been testified to by the experts in this case. Delusions, hallucinations, disorganized thinking, we heard about that from Dr. Dudley and from Dr. Jackson, and negative symptoms, withdrawal, impairment of functioning.
And you understand, as it relates to that point, that there can't be reference to that in the questions. What's the name of this expert again? I apologize.
Dr. DeVere.
Yeah, I'm sorry. I can't remember. Dr. DeVere. You can't reference, in this case, has been.
Right. I understand that completely, and I intend to stay completely away from it. But what she's going to do is give the landscape of psychosis in children and young teenagers and what that what they look for, what's important, and what it's likely to be, and why the diagnosis is not otherwise specified, and also how psychosis presents itself in children and young teens.
And it's the Boston, and I know you're not going to reference any questions related to Boston Medical Center or Worcester recovery, but are those the only two areas of records that she reviewed?
I'm not sure. She may have reviewed records concerning, no, those are the only two records that she reviewed.
Okay, all right. Are you all set, Ms. McDougall?
Dr. Dudley's still here, by the way.
But, oh, I don't think there was, is there any recross?
No.
Okay,
Okay.
okay. There's two choices I have.
I'm aware of what the choices are, Your Honor, and I don't,
Do you need to be heard further, that's all I'm
I would
asking.
ask for 5 minutes to speak to Mr. O'Sullivan.
Can you have the jury go back for a moment, please?
I don't believe so, Your Honor.
All right, but you want 5 minutes, right? All right, court will be in a short recess.